All right, good afternoon, folks. This is Curt, and we're here for another edition of Fire Law Roundup. I am flying solo today, though. Brad apparently told me, and he did tell me that he was going to be away, but I thought it was next week. I didn't think it was going to be this week. So it's going to be a little bit different. Also, my computer is down, and I'm using a backup computer, so I don't know how the quality, particularly the sound, it looks, at least from what I can see, the visual looks okay. But we're going to do our best, or I'm going to do my best to try to cover last week's stories in the best way that I can anyway. So let's start with the case out of Massachusetts. It's a whistleblower case, a firefighter out of Natick, Mass. It was terminated at the end of his probationary period, 1-year probationary period, and there was a couple of moving parts in this one. Number one, he claims that he was asked to sign off on a document that he felt was not correct, it would have been false for him to have signed it. I'm not fully I don't fully understand what the purpose of the document was, but it was something that he was supposed to sign, and he refused to do it. Had to do with the evaluation that either was or was not performed by a paramedic on a medical run. And 2 weeks later, he was terminated, and he's alleging a couple of things. One is that the fire department and the fire chief didn't follow the right procedure under Massachusetts law to terminate him. And this took place in January of this year. The termination took place the initial termination took place in January of this year. I apologize if you see me looking in an area where I'm not looking at the camera, but I'm looking at the my write-up on the case. But he said the fire department didn't follow the right procedure. Okay, so that's sort of problem number one. And his probationary period would have ended. He was hired February 23rd, 22. It would have ended February 23rd of 23. He was terminated on January 31st of 2023. So it was 3 weeks short of his anniversary date. He went to an attorney, and the attorney kind of skillfully waited until February 24th, as I understand it, and sent the city a letter saying, hey, by the way, you terminated my guy. You didn't do it properly in accordance with the law. And now he's reached his 1 year. And so therefore, you've got to take him back. You didn't terminate him properly. So that was sort of, one issue in the case. The other has to do with the fact that he complained about being ordered to do something that he felt wasn't right. And then within 2 weeks, he was terminated. And when he was terminated, he wasn't given a reason, which creates an inference, assuming that what he said factually is true, that it was retaliation. And Massachusetts, I've got a link in the article on it, but Massachusetts state law, that whistleblower law, let me see if I can get the right one here. Let's see, there's a couple of different statutes in there, but the link that I've got, let me just click on the link and it'll take me there. But the whistleblower law is chapter 149, section 185, is a lot broader than most states' whistleblower laws. Many whistleblower laws say if, like, for example, OSHA, that you've got to, well, I guess OSHA's isn't quite that narrow, but some of them you have to be reporting something to an authority. You can't just complain about it to a supervisor, and you can't just refuse to comply with it. Massachusetts law considers refusing to comply with an illegal order or something you're told to do and you don't do it, that's illegal, falls under the whistleblower. So that's a little bit unusual. And that's the crux of the case, that he wasn't properly terminated, and therefore he vested on February 23rd as a tenured employee, and now you've got to produce cause. And then the other one is that he was fired in retaliation for his whistleblowing activity. So there's a little bit more to it if you want to read the complaint, a little bit more that gets into the department tried to refire him. They tried to allege that he, when he was at the Mass State Fire Academy for whatever it was, 12 weeks, that his tenure, his probationary year, was told. So basically, when he came back from the fire academy, his probationary period had to be extended an additional 12 weeks to cover the academy time, which, pretty decent argument. When you don't have a good argument, you make that argument. Unfortunately, this apparently, according to the complaint, there's evidence that, or allegations that the chief had congratulated the other firefighters from the same department that had completed their 1 year. They had been hired the same day. They went through the same academy, and they reached their point of tenure on the same day, February 23rd of 23. And the chief apparently congratulated them on that date. So there's nothing about them having their probationary period extended. It was only this particular firefighter. So we'll see how it shakes out. Probably is going to result in a settlement, but you don't know if the facts aren't as explained in the complaint. You got a different situation. Next case is out of Seattle. We've got a firefighter, a captain actually, who filed a suit, a discrimination suit, and it's not his first one. I've got him in the database on at least one other lawsuit that I have connected my previous coverage of it, but he's alleging that he's being discriminated against on the basis of the fact that he's Asian, African American, and Caucasian. At least that's what he is alleging, and that he is being discriminated against because of his race, but also because of his disability. And the disability is not identified in the complaint, so I'm not sure what exactly that is. And beyond that, we don't know much more than that. Okay, but he's alleging that he did not get a promotion, which I assume would be to a chief's position. He's a captain, so he didn't get a promotion to a chief, and there was some sort of either a race discrimination or disability discrimination in play there, and retaliation. So, but that is the Cincinnati case. Next one is one that we've been following, and I wish Brad was here because I know that he knows a lot of the people personally. I've met some of them, but I can't really say that I know them personally, but I certainly know of them. But we've got several chief officers suing the commissioner, and this particular, they've made a number of allegations. There's been a couple of lawsuits. This particular one involves age discrimination. And the case was filed originally in March. There was an earlier case that challenged their demotions that was filed in February, and that case subsequently has been dismissed. So this seems like it's the primary vehicle that they're airing their concerns. And but at any rate, the complaint was amended. And there were some additional allegations in very concerning allegations as well. And again, we don't know factually whether or not everything's going to bear out this, but the allegations were that at least one of the chiefs, if not a couple of them, had expressed their concern to the commissioner about the e-battery, the lithium-ion batteries, particularly with regard to e-bikes. And wanted her to take a position that would have blocked e-bikes from being present in public housing in the city. And according to them, she was not willing to do that for political reasons. And again, it's not quite clear if that is going to be sort of that, they were advocating that she do this and then she retaliated against them, whether or not that's going to be, part of this whole messy, ugly airing of the laundry at FDNY headquarters. But again, you can read the allegations, you can read the complaint, lengthy complaint. And some of the quotes there are from the, the firefighters or the chief's attorney, talking about, the context in which this refusal to come out strong in support of the fire department and recognizing the dangers associated with these e-batteries. So again, there's been a number of fatal fires in New York. I'm not sure any place in the world has had the number of deaths due to these batteries that New York has, but there's been a number of fatal fires, and I don't think this problem is going to go away. According to the complaint, the commissioner's concern was that it would burden economically disadvantaged people if you prevented them those types of vehicles from being present in public housing. That was her concern. She subsequently has come out and she some of the statements from FDNY press releases are that she's a leading advocate nationally in support of bans on these lithium-ion batteries. So again, we'll see how that all shakes out. Okay, so that's the FDNY case. We got a case out of San Antonio that a San Antonio firefighter, relatively new, I think he was only on the job for a little over a year, might have been 2 years, but wasn't on for very long, and he ended up resigning. And he claims that he was being discriminated against because of his sexual orientation. Folks made fun of him, called him names. And he was afraid for his safety that folks wouldn't help him. Colleagues would not help him at a fire, and that he could be injured or killed. So we'll see how the facts play out. One of the challenges here with this sort of hostile work environment type of allegation, we see this more with regard to sexual harassment against women, but it can be male on male sexual harassment. But you've got to show that there was either a severe or pervasive condition that you were exposed to that warranted you leaving, that basically you were incapable of doing your job. He makes an allegation of a couple of things, but I'm not sure any of them, I would certainly none of them in and of themselves is severe. And I'm not sure that he's going to be able to prove pervasive. So I think he's got a tough case to make. But again, the complaint doesn't always list all of the allegations, and we'll see how that that case in San Antonio goes. Let's see, last case here. Last case is an interesting case, and I'm not an expert. I didn't study admiralty law. I studied copyright. I took a course in copyright and trademark and some unusual kind of outside the box kind of legal issues for firefighters anyway. But I didn't study admiralty law, and in this case, it's out of FDNY. We're back in FDNY again. But we've got a Belgian firefighter from Belgium, and his wife apparently were on a FDNY marine unit, 31-foot inflatable, a hard-sided inflatable, out in, I'm assuming the river out there, Hudson River, and they collided with a tour boat. And according to the Admiralty complaint, now, the way that Admiralty works a little bit differently than normal courts. First of all, federal court has jurisdiction over Admiralty claims. But the first thing that happened, now the boats collided. This Belgian firefighter was killed. His wife was injured, and now obviously she's got a claim. So the first sort of legal proceeding here was the boat that collided with the FDNY boat. That the captain of that boat and the owner of that boat filed suit against New York and the Belgian folks in Admiralty. And what they were seeking was the Admiralty court, or the federal district court, basically sitting in Admiralty, they call it, to declare that they were not at fault for the accident. Okay, so it's a little bit unusual here. It's typically the people you think are the defendant are actually filing the complaint, and they're going against the people who should be the defendants, or should actually, should be the plaintiffs anyway, at least as far as the Belgian folks go. And so you got a mixture of people who could be plaintiffs and defendants, now defendants in that initial action. So once that initial action has been filed, now we have the Belgian firefighter's widow in his estate filing suit against everyone else. They're suing FDNY, they're suing the captain of the boat, they're suing the owner of the other boat, the tour boat, and alleging that they held some level of responsibility for it. So interesting fact pattern. Who knows who was at fault? Certainly from the complaints and the pleadings in the newspaper accounts, I don't think it's necessarily helpful to assume that FDNY was at fault or that the other boat owner was at fault. We just know that there was an accident and someone was killed, and now we've got this mess of a lawsuit that folks are going to have to deal with. Okay, so you've got a copy of both of the complaints there, the two complaints. The first one filed by the boat owner and the captain of the ship against the folks who were injured in FDNY, and then you have that second one filed by the firefighter's widow. So that's quick, and I think I ran through that in about 20 minutes, a lot quicker than Brad and I usually get through it. But I think having both of us there to give Brad's insights, and I think that works a lot better for us. But there's going to be weeks where I'm not going to be able to do it as well. So. But that's going to do it for another edition of Fire Law Roundup. If you haven't already subscribed, please do. We need to get our subscriber numbers up. Please binge watch. We need to get another couple of 100 hours for us to get to the next tier on YouTube, and we really appreciate your support. Click share, click like, let your friends know about us, and we'll see you again next week for another edition of Fire Law Roundup.